All right, so today is August 6th, 2024. I officially call this meeting to order. First order of business, we have approval of minutes, which I have here. I have reviewed these, and unless there's any objection by anybody, I will go ahead and sign these. These have been on, I believe, on the website with the agenda, so I do approve of these minutes here, and I'll go ahead and get these signed so we can get them entered. All right.
Madam Magistrate,
Yes, so, yes.
we're going to be asking, the town will be asking to reorder the new cases to be heard and move item number C up before B, so it'd be A, C, B.
No problem. Yeah, that's fine.
Okay.
Okay.
Thank you.
All right, so to introduce myself, my name is Monica Schmucker. I am the appointed special magistrate to hear today's code enforcement proceedings as provided for in Chapter 2, Article 5 of the Fort Myers Beach Land Development Code and Florida Statutes, Chapter 162. I am a licensed Florida attorney in good standing with the Florida Bar and a Florida Supreme Court certified circuit court mediator and qualified arbitrator. I'm qualified to serve as the appointed special magistrate for the town of Fort Myers Beach. At this time, I would like to ask that everybody please turn off your cell phones if you have not done so already, or put them on silent or do not disturb so that they don't go off during today's meetings. This is a quasi-judicial hearing, which means it's similar to a case in court. The rules are less formal. My role here today is to hear fairly and objectively review the cases that are here before me today, apply the facts and all the evidence before me to the law. Formal rules of evidence do not apply, but fundamental due process will apply and will govern the proceedings. The cases will be heard in the order of the agenda, with the exception of that change. C will be moved above B in the agenda on the new cases to be heard. The town has the burden of proof on all cases, so the town will present first, and then the alleged violator will have an opportunity to then speak, present evidence, and refute any of the allegations. All parties who are here to speak on a case will have the opportunity to do so. At the conclusion of each case, or within 15 days, I will issue findings of fact, conclusions of law, and in an order, affording the proper relief that I find to be consistent with the powers under the code and Florida law. So at this time, I would like to ask everybody who is going to provide testimony to please stand up and raise your right hand for the taking of the oath. Do you want me to administer it, or you?
I can do it, you can do it, it's up to you.
I'll do it.
Okay.
Do you swear or affirm the testimony you are about to provide is the truth, the whole truth, and nothing but the truth? All right. All right, thank you. So the first order of business was to approve the minutes, but we went ahead and did that. So next will be the cases, and the first one is case number 20220371 on the agenda. Is the town ready to proceed?
Good afternoon, Your Honor. I'm Officer Batt, Code Compliance Officer for the town of Fort Myers Beach. I have been sworn in and will be providing testimony and documentation for case number 20240249. The property owner is requesting a continuance for this case to September 4th, 2024, as we have made contact with the property owner, who is currently out of country, through phone and email, as our goal is ultimately compliance. The town is agreement with the continuance, as some additional time may allow us to achieve this goal. Please accept a copy of the emails and permit request information, which was submitted on 7/11/24 into the record to show effort having made.
Is that, and I'm sorry, you state your name and you represent, are you speaking
Town
on
of Fort
behalf of
Myers.
the town?
Yes, ma'am.
Thank you, just for the record. And so you've been in communication, you said, and you're working on compliance. Okay, and the town has no objection to a continuance?
No, ma'am.
Okay. Then, I will grant a continuance until September.
4th.
I'm sorry?
September 4th.
Okay, September 4th, right, the next
Mhm.
magistrate hearing.
Your Honor, once again, I'm Officer Bat, a code compliance officer for the town of Fort Myers Beach. I've been sworn in and will provide testimony and documentation for case number 2024-0249.
No, C.
See, yeah, 2024-0316 is the next. We moved, yeah, we moved C to B.
Okay.
We just got the wrong number.
Yeah, I apologize.
Oh, no problem.
I was like, wait a minute.
Your Honor, this one is also going to be a request for continuance, but go ahead, Officer.
Yes, it is case number 2024-0316. The property owner is, again, requesting a continuance to September 4th, 2024, as we have now been able to speak with the property owner by phone and email. As our goal ultimately is compliance, the town is in agreement with the continuance to September 4th, 2024. The town would also like to ask that you make note in the record that the case has been referred to the building department or building official for further safe structure determination. Please accept a copy of the emails into the record to show efforts have been made towards compliance.
The town, you said, is okay with,
Mhm.
okay, there's no objection to that, then continuance to the September hearing would be granted.
Once again, good afternoon, Your Honor. My name is Officer Bat. I'm a code compliance officer for the town of Fort Myers Beach, and I have served in the capacity for approximately 6 months with 5 years prior experience elsewhere. I've been sworn in and will provide testimony and documentation regarding this case. Our documentation is attached to the agenda as exhibits, and we ask that all documents are accepted into evidence.
I've reviewed all the documents to be admitted.
We bring before you Fort Myers Beach Code Enforcement Case Number 2024-0249. The subject property is located at 1661 Estero Boulevard, Fort Myers Beach, Florida 33931. Exhibit A contains the documentation that the respondent, Kyocera Shops LLC, owns the real property that is the subject of this code enforcement case. Included in Exhibit A is a copy of the warranty deed, a copy of Lee County tax collector receipt, a copy of Lee County property appraisers, and a copy of Michigan's Department of Licensing and Regulatory Affairs Corporation's online filing system showing Aurora Colorado as a registered agent. The subject property is not currently homesteaded. The current use of the property is commercial. It is zoned downtown, and its future land use is pedestrian commercial. Moreover, there's no evidence that the subject property is eligible for a homestead exemption in the Lee County tax collector's records. On March 18th, 2024, I observed Kyocera Shops LLC in violation of the town of Fort Myers Beach Code ordinances, specifically the operation of shared parking lot in the public for a fee per vehicle space without first obtaining a required use permit at the subject property. True, accurate, and unaltered copies of the pictures that I personally took on the date of first site inspection have been marked as Exhibit B and introduced into the record.
Danielle, can you pull the mic just a little closer to you? Like lift it up higher. The whole arm. There you go. Thank you. We weren't picking her up.
In these, I get it. In these photos, on the top left, you're going to find standard parking lot with vehicles in it. Top right-hand corner, you're going to find a parking attendant sitting in a chair, and to the far right, a sign with a cost. The bottom left-hand corner, you're gonna see a sign that states parking $20. And another parking attendant exiting his red truck. In the fourth photo in the bottom right-hand corner, you're gonna see a generalized photo of all of the above. A notice of violation was issued on March 21st, 2024, and sent by certified mail to the address of record, specifically to 3220 Pine Cone Court, Milford, Michigan, 48381, posted on March 21st, 2024, at the subject property and at Town Hall located at 2731 Oak Street, Fort Myers Beach, Florida, 33931. Furthermore, a copy of the notice of violation was sent via certified mail to the registered agent at 3220 Pine Cone Court, Milford, Michigan, 48381, and sent to site location at 1661 Estero Boulevard, Fort Myers Beach, Florida, 33931. True, accurate, and unaltered copies of these documents including a copy of Section 2-249 have been accepted as Exhibit C. Kia Stero Shops, LLC was given 30 days to come into compliance with the Town of Fort Myers Beach ordinance and notify the town on or before April 27th, 2024.
Should she just hold it?
It just keeps moving.
I performed a reinspection of the subject property on July 8th, 2024. As no notification was made for compliance, and the subject property was in violation of the town's Fort Myers Beach ordinance, there did not appear to be any progress towards compliance at the property. Based on my reinspection of the subject property, I secured an affidavit of non-compliance. A true, accurate, copy of the March 15th. Accepted. As a result of the subject property, failure to bring subject property with section 34 of the Land Development Code, they were provided with a notice of code enforcement. Copy of section 34 203 Town Code has accepted evidence as a. Your Honor, at this time, I would like to ask to add exhibit to establish that the property owner is knowledgeable that he cannot lawfully park his car on the subject property. This is a repeat violation due to case CE 19-0026, which started in 2019 for the same offense in which the previous magistrate found a violation and imposed a lien on the subject property on September 2nd, 2020. In Exhibit F includes the notice of violation for case CE 19-0026, the order to lien for case CE 19-0026, the affidavit of compliance for case number CE 19-0026, the release of lien for case number CE 19-0026, copies of the notice of hearing, photos of the notice of hearing posted on July 10th, 2024, to the violation property located at 1661 Fort Myers Beach, Florida, 33931. A photo of the notice of hearing posted on July 10th, 2024. Town Hall located at 731 Oak Street, Myers, Florida. All certified receipts for the notice of hearing. Tracking history from USPS for the notice of hearing. And the photo of the condition of property at the time of inspection on August 1st.
The release of, or, we'll add that information to the record.
Total amount paid for the release is $1,088,000. Based on my sworn testimony, the evidence that is presented, including the exhibits to the agenda packet, now to the town of Fort Myers Beach, I request an order be issued finding violation of section 34 order to correct the listed violation and the
Can- Madam Magistrate, can we take a break? Can we have her sit over at one of those other microphones and give her testimony? That one's not
It's
working
not
correctly.
working. Okay.
Yeah.
Yeah, that's fine.
Yeah, sorry. I would, not the whole thing, maybe just read your last thing you're reading, so it's on the record for sure. I'm sorry.
testing. Testing.
Perfect.
Based on my sworn testimony and the evidence that has been presented to you, including the exhibits within the agenda packet, on behalf of the town of Fort Myers Beach, I request that an order be issued finding a violation of section 34-3203, including an order to correct the above listed violation and the imposition of an administrative fee of $250 to cover costs in bringing this matter before the special magistrate. To establish a repeat offense, and we're asking you impose a fine not to exceed $500 for each day each violation continues past the date of for the compliance, as this is a repeat violation, and for such other and further relief as is consistent with the powers of the special magistrate. As of today, it has been 141 days since the repeat violation was identified. And at $500 per day, it totals $70,500 in fines accrued. We are asking that you impose fines from the day the violation was identified until the subject property is in full compliance. To come into compliance with section 34-3203, the property owner will need to cease activity and or get the appropriate use permit to allow for the parking of vehicles for fee. To this fact, I have senior planner Jason Smalley available for testimony and further explanation of how to obtain a use permit if required.
Did you say you had him available?
Mm-hmm. Thank you.
Do we have a respondent or somebody here representing the respondent? Thank you.
We might have to move.
So
You want her to sit here?
We can, no, I'll move over. She can sit here.
Or-
Or,
Sure,
that one's
what-
just-
however,
I'll move over here.
okay.
You don't mind me sitting here?
No,
Sorry.
It's all right. Don't worry about it.
Good afternoon, Your Honor.
good afternoon.
For the record, Amy Thibault with Bretzel and Andrus. I've been sworn. Our offices represent the property owner. And first and foremost, I would like to thank Officer Bat and the town attorney for taking the time to discuss this issue and work through it with me on behalf of the property owner. Before I get into the current situation, it's imperative that we talk about the history of this property a bit, because I think it'll provide a bit of clarity regarding the current use. So, this site was originally approved for development, commercial development in the 1970s. In 1980, the immediate predecessor to the current property owner purchased the property and began using it as a commercial parking lot, in part. When this entity sold the property to the current owner, that use continued. And it's important to note that At that time, this area was part of unincorporated Lee County. And the county had zoned this property BU1, and this is a very challenging to read snippet from the zoning regulations in place at that time. But BU1 permitted commercial parking lots by right. So when this use was established, it was permitted by right, and it continued through today without any cessation, making it a lawful non-conforming use, as we'll get into in just a little bit. The previous case was a bit challenging. So the property owner did challenge the finding of violation and the fines that were imposed at that time. However, that appeal was dismissed on procedural grounds. The court found that the time to appeal had run. I believe it was because they had sought an appeal at the local government level, but regardless, the merits of whether this was a non-conforming use or not were not actually litigated. So the fines continued to accrue, and they were recorded as a lien against the property. I believe it was in 2022 when the town took action to foreclose on this lien, and ultimately that case was dismissed when the property owner paid that fine. It was $188,400. So they paid the fine to avoid foreclosure on the property, but the substantive issues were never contemplated in court. And the reason that this matters is because, I'll move back here, the ordinance requiring special exception approval and actually establishing the downtown zoning district was adopted in 2004. So by the time that ordinance was adopted, this use had been in place for 24 years, again, making it a lawful non-conforming use without cessation. So fast forward to today, the violation, as Officer Batt already testified, was issued in March of this year. And in response to that, the property owner, through our office, has submitted an application for special exception to legitimize the use, even though this is a lawful non-conforming use. And I will note that the delay between March, when the fine, or when the lien was paid off and released and that case was satisfied, and when the special exception application was submitted, was delayed not by the fault of the property owner. There was a transition. I joined the firm a couple of months ago to take over a role for someone else, and it was just something that had slipped through the cracks in that time. So it really was not the property owner's fault that the application was submitted almost 4 months later. So I will note that. So again, just basic Florida law. The ordinance that was adopted requiring the special exception in the downtown district was adopted in 2004, and it was not a retroactive ordinance. It wasn't intended to apply retroactively, as demonstrated by section 34-621A, which states that certain lawful non-conforming uses may continue. And as another note, because zoning regulations are in derogation of private property rights, they are to be interpreted in favor of the property owner where possible. So the town's non-conforming use standards state that non-conforming uses may be continued subject to limitations, which really is that, they can't be expanded. There's limitations on replacing them. I won't bore you to death. I think we all are aware of what those limitations are. But this is, again, we would submit a lawful non-conforming use. So Florida law has long recognized that lawful non-conforming uses can generally be grandfathered in and continued on property subject to those zoning classifications unless they're terminated or unless there's some other valid retroactive purpose at play. And again, here, to the extent that this is it's a lawful non-conforming use, but to the extent that, property ownership would have affected this, Florida law is clear that a transfer of title to property doesn't affect whether a use is, an existing lawful non-conforming use is valid or not. I will also note that Florida law does permit equitable defenses in code enforcement cases. And the Town's Land Development Code does as well. So to the extent that, you find that for whatever reason this is not a lawful non-conforming use, we would assert that the property owner has in good faith relied on the zoning conditions and the use as an existing lawful non-conforming use based on that BU1 zoning that was established prior to 1980 and prior to the establishment of the use on the property pursuant to the Lee County first zoning resolution, Z1. And as a result, the property owner has relied on the income from the shared parking, that paid parking, commercial parking lot, whatever, terms we want to call it. They've relied on that as income to help maintain the cost of the property, pay property taxes, rehabilitate the structure, keep it on the tax rolls. So Florida law does hold that a favorable zoning ordinance is an act of government for purposes of equitable estoppel. And a substantial change in position does factor in the entire plan of development. So the fact that this was developed with not just the retail shopping center in mind, but also with the paid parking, does establish a substantial change in the position for purposes of equitable estoppel. We would also argue that to the extent this is a violation, latches would bar fining the property owner at this point because the property owner has been conducting this use on the property for over 20 years, and if you include the predecessor, approximately 44 years. And at some point, whenever this was made, whenever this became a violation, the property owner was unaware of it, and there was unreasonable delay in that 15 years before this was first enforced. This was not first enforced until 2019. And they really did not have a way of knowing that for that 15 years, and now they are certainly, they would certainly suffer injury upon a finding of not just a violation and the imposition of fines, but a finding of a repeat violation and the imposition of the max $500 per day fines. I will also note that in 2022, the Florida legislature adopted section 715.075, stating that the owner or operator of private property used for motor vehicle parking may establish rules and rates that govern private persons parking motor vehicles on such private property, and that a local government may not enact an ordinance or regulation restricting or prohibiting the right of a property owner to do that. It's unclear, I will acknowledge, whether this applies to this case or not, but I would submit that it does, given the totality of the facts at play here. Again, this use has been established for over 40 years. They've been using it as such, and really, there's nothing in the code that would prohibit the continuation of the use absent termination of the lawful non-conforming use for, I believe, a period of 9 months. So with that, in an effort to demonstrate good faith, we're simply seeking more time before fines are actually imposed. And this would allow for the review and hopefully the approval of the special exception application that we submitted on July 11th. In that same vein, we would be willing to return and provide periodic status updates to demonstrate our good faith efforts to obtain the special exception to bring this up to current site design standards and other things that will be required in conjunction with the approval of the special exception. And with that, I am available for questions if you have any.
I do, but I wanted to give you the opportunity to respond.
Happy to do so. Nancy Stupridge, I'm with the Vos Law Firm. We represent the town of Fort Myers Beach. First of all, this is the first time that the town has been made aware that the property owner is asserting some type of right as a legal non-conforming use. Clearly, there has been evidence placed in the record, alluded to by the property owner's counsel, that there is a prior case for the same issue that is brought before the special magistrate today. And again, in that case, there was never, ever any type of allegation that this was a legal non-conforming use. We think that it's inappropriate at this time to bring that up. Also, they have applied for a special exception, and we do have our planning and zoning staff member here who is an expert on the Fort Myers Beach, or has been accepted as an expert on the Fort Myers Beach Land Development Code. The current code requires a special exception to be approved in order for a shared parking to be allowed. Otherwise, it is an illegal use, and under Section 34-3203, as an illegal use, it is a code violation. We have not had the opportunity to cross-check any of the legal citations that have been provided to you. Again, this is the first time that we have heard an allegation from the property owner that this is some type of legal non-conforming use. So I would, at a minimum, request the opportunity to have time to look at the legal citations that have been provided and to provide a brief to you on the issues, the legal issues that have been raised.
Okay. All right, I do have a few questions. Is your position that the town of Fort Myers Beach cannot enact an ordinance requiring a permit? Is that what you explained? Because I believe that, you put up a statute there and you said that you couldn't restrict the right to use the property as a parking lot. So is my understanding correct? Essentially what you're saying is that it would be a violation of law to require a permit to operate a parking lot?
I don't think it would extend as far as not requiring a permit. It's more putting that, I will note that there's no case law on this, and I have seen varying interpretations of whether this extends only to the ability of a private parking lot owner or operator to establish their own rates and rules, or if it extends to preempting town authority to regulate this use. In the interest of collaboration with the town, we're already going through with the special exception application. We don't intend to rescind that. We intend to go through with it. So it's not that we're sitting here today asking you to invalidate the shared parking ordinance requiring a special exception in certain zoning districts or PD development and others. We're simply asking you to consider that this is a lawful non-conforming use that has been continued. And I'll make a quick note that when this case first arose, there was a completely different town government here, different folks, different town attorney, different planning staff, different code enforcement staff. But the property owner's attorney at that time, Mr. Steve Hartzell, did assert that this was a lawful non-conforming use. And at that time, the town attorney disagreed. It is still my opinion that this is a lawful non-conforming use, given that it was established in 1980 when this was permitted by right, pursuant to unincorporated Lee County zoning, and has continued without cessation. And those, both the affidavits and the zoning regulation that I put in my PowerPoint were included as part of the original presentation to the town from Mr. Steve Hartzell, and they were included as the appendix to the property owner's appeal that they filed in 2020. I would be happy to submit that as part of the record after this hearing, if that would be amenable to everybody.
Okay.
But I believe the town should have records of that also.
Go back to that. Well, I don't. right? So the evidence in this case is the evidence in this case.
Yes.
And are you saying that there's some undue burden to apply for special exception or permission to be able to operate? I mean, is that what you're saying, that there's some undue burden being placed on them for such an application?
Technically, I would argue that a lawful non-conforming use can continue without a special exception if it was lawful when it was established, as it was in this case. However, in the interest of cooperation with the town and to really just put this issue to rest once and for all, we have applied for the special exception and we are seeking that and we are going through the process.
Sure, and I get that. But just, as a reminder, this is not the 2019 violation, and there's no evidence before me of anything that happened between 1980 and 2019, or whenever it is that the original case was. However, as far as the latches argument, it wasn't brought up in 2019. This isn't 2019. That case is done, right? So this is a new one, and it is a repeat violation, and I do appreciate that there has been an application. I will say this, as a repeat offense, right, or a repeat violation, it would begin on the date of the inspection, okay? The fines would begin to accrue. I would be willing to give the parties the opportunity to provide legal briefs on this matter, because I understand and I recognize that it is not necessarily that simple. I would like to further look into the legal authorities that you have cited.
Mm-hmm.
I did not memorize them, but I would like to give the parties an opportunity to brief it. So, all right. I will not issue a ruling on this hearing. What I will do is give the parties, I don't know, do you have a request as to an amount of time that you may need to research and brief the legal issues that were brought up today? Because I would like to rehear it at the next hearing. But I will say, as I see things today, if I were to find that it is a repeat violation, up until the point, right, up until, like, from the day that it started until the day that it ceases or it becomes legal, those fines will accrue. So they will continue to accrue.
Okay. And to clarify, these will just be briefs on the law as applied to the facts in front of you today?
Yeah, and if there is, and I don't know, you mentioned there was something before, or that the town has records of, if it's relevant to what you're saying in application to the law, I'd be happy to take a look at it. We need to make sure everybody.
I'll coordinate with the town attorney on that.
Your Honor, other than today, other than seeing some legal citations brought forth on a PowerPoint testimony of counsel, we don't have any of this information, and I don't think it's appropriate for us to submit a brief to you to actually do their work for them if that's their argument.
I understand. I don't believe that you should.
Thank you. And so I think that perhaps the correct procedure would be to have them
Do a brief, and
submit
then
a
you
brief,
would
and we
have
would
time to do a
respond
response.
to it.
Absolutely. That is, yes.
Thank you.
So-
And I mean, we would not necessarily be opposed to a continuance if that is, or not a continuance, but a period of time for compliance. Compliance can occur right now.
I agree. And I wasn't done.
Thank you.
Okay.
And, they are going to need some time to get that special exception to make them a legal use.
Right. Yes, I
Those
agree.
are my 2 cents.
And that's where I was going. So,
Okay.
as it stands right now, right, if he's operating a parking lot without the special exception, regardless of, if he's out there today, I don't know, but like I said, it will continue to accrue, and it will be $500 from the March date that was provided every day. And unless there is some sort of, I find that defense compelling, I don't, the issue is, if there is a compelling defense, I don't want to issue, your client needs to figure out what he's going to do, okay? As of today, right, if he's continuing to operate a parking lot and it isn't found to be legal, it will continue to accrue. However, I'll give you the opportunity to brief it, and I will want to hear it again in September. Could I ask you a question? You said that he submitted the application for permit on July 10th?
July 11th, yes.
Okay. Could I ask you what that process entails?
I will defer to Jason Smalley, but I did see a signed document in the packet in Exhibit F, where I believe the client signed it, or it was dated back in April. And it would be my position that if the citation was, the notice of violation was granted in March, in April, they knew that they needed to go through that process. The fact that it perhaps has been delayed for, I don't know what reason, to July, again, gives him that period of time from April to July to continue to operate in violation of the town's code.
I agree.
And that is really not,
I
it's
agree.
not where we are.
No, I understand.
so-
So here's my question. I want to know what the application process is, or what it is, or the timeline.
So I would.
And in response,
Yes.
okay, I will say that the fact that an application has been submitted does not cease the fines from accruing.
Yes.
So if I may, Your Honor, I think he has been sworn in. If we could hear testimony from
Yes.
Jason Smalley. Just as a point of introduction, he is one of our planners with the town of Fort Myers Beach, and he can give you the nuts and bolts of the special exception process.
Good afternoon, Your Honor. My name is Jason Smalley. I'm the senior planner here with the town. I've been in this position roughly 2.5 years. Prior to that, I was 5 years with Marco Island. Your question is one of process. The application for a special exception would be accepted by the Planning and Zoning Department. At that point, we would go through a review. As a rule of thumb, I would state that a good review should take somewhere about 60 to 90 days before we schedule for initial reviews before LPA, followed by a town council reading, which would give a proper determination of positive or negative on the request. That special exception process is laid out in the LDC. There are some key items that the town council is required to look at for determination of whether or not they will approve it. But otherwise, the process itself is fairly straightforward: application, review, and then readings.
So you said 60 to 90 days.
That is a good rule of thumb for application to readings.
All right. Okay, thank you.
Thank you.
Okay. Based on what I'm hearing today, I will give you the opportunity to brief the issue. We could revisit this in September. Once you've briefed the issue, I can give you, what's today,
The 6th.
the 6th. So I'll give you 10 days.
Perfect, thank you.
I'll allow the town 10 days to respond. Does that work? Then what I will do, I would like to bring this hearing again. We can continue this hearing to conclude next month. And at that time, I'll be able to issue a ruling, or I'll take whatever is provided to me under advisement. And again, I will tell you that the fact that he's applied is not going to stop those fees from accruing. So that's what I can tell you. Okay?
Thank you, Your Honor.
Okay? Anything else? Go ahead.
Well, in the event that he should continue to operate, then from this period of time from today's hearing to as a new violation.
Do what you need to do.
Okay, thank you.
Okay?
Thank you.
Okay? All right. Thank
Thank you very much.
That's it for this one? So I think we have one more item. Okay, so This is a public notice for order of compliance that was issued. I signed the order of compliance previously, and it was related to KCE 20-0239, 215 Flamingo Street. And there's really, I mean, I don't know if anybody has any questions as to this, but no. Okay.
Your Honor, it's just a follow-up on the code requires the filing of the order of compliance administrative. We are bringing it to the public hearing, that way it's part of the record. So if anybody needs to do something, we can find it.
Okay. All right. Okay. Well, then I think, yeah, I think that's it. That's already been entered, so there's nothing left to do with that. And with that, then this meeting is adjourned. Thank you. That sounds funny. I like it too. Do you need this here?